You know, we fared better than most, but I appreciate the hard work of everyone around.
And when you're the one that's still out of power, it's like...
It's the worst. It doesn't matter if I think there was almost 100,000 people in the region, but if you're one left, it doesn't matter. So.
Looking at your neighbor's lights across the
It's the
yard.
worst.
I borrow a couple of electricity.
I was one that only
You do
for a
appreciate
few
it for
hours.
about 15 minutes after it comes back on, and then you just kind of used to it again.
But internet was out for me for a long time.
Yeah. Back to the originally scheduled announcements. First is a check over $25,000, which was for a police vehicle from Schultz Ford for $30,125, which we actually have already bought. Might already be in use. Next, I just want to announce that there will be a public meeting on the comprehensive plan update and public hearing on the draft generic environmental impact statement on Wednesday, March 21st at 7:30 p.m. That's here in Village Hall. More on that down below. Next up is correspondence from Chet Kerr on behalf of the Greater Irvington Land Trust, the Open Space Advisory Committee. If you just want to say something rather than...
Well, I didn't know if I should say something, or I would just let you read the letter, but I'm Chet Kerr, and I just wanted to put this in context and just tell you what else I can hopefully do. We sent the letter on behalf of the Greater Irvington Land Trust, the Open Space Advisory Committee, requesting the village to designate as parkland 6 parcels of property in the northern end of the Irvington Woods. These are parcels of property that were acquired by the village out of the whole Westwood development and transactions that extended over 25 years. And we've outlined in our letter the reasons why we believe that these should be made into parkland. The village had made that commitment, both contractually committed and to the residents as well 15 years ago. And we think there's a lot of good positive reasons to do it as well. So I know I sent a big binder of materials, and I apologize for doing that, but I thought it would be helpful. And I'm more than willing to talk to the board and answer any questions you might have about any of this material at a work session or whatever, or offer any other help I can do to help you understand that. I also want to say that I have all of the underlying source documents in both hard copy form and electronic form, so if somebody wants to see them, you're welcome to them. I'm more than willing to provide them to you. I am actually, as I've talked to Larry, I'm actually away for a month starting next week, so I suggested, Larry, perhaps that when I get back, if I know you're very busy right now, but if there was something I could do. But I'll leave it to you,
Great.
whatever I can do, okay?
Yeah, I think, it obviously was well thought out, well researched, and well documented, so we'll digest it, we'll, meet up with Mary Ann, and then I think a work session.
Yeah, I have another copy of that if Mary Ann wants it. She may not want it, but please give it to her.
I think if she puts everything right there.
Yes.
Ted, I would just mention it would be worthwhile speaking with RPAC and the Woods Committee. I know that you say that you had spoken with the Woods Committee.
Yeah, so let me tell you what I've done. I've met with the Woods Committee and both gave them a set of the materials, outlined, and at Joe's suggestion, I offered to meet with RPAC as well, and I'm kind of waiting for Joe to let me know when and if he'd like to do that. So I'm available to meet with them and to answer any questions I can on this, because I want to be as helpful as I can. Okay?
I
Great.
think we'd be curious to hear what they have to say.
I agree. Okay, thank you so much.
Thank you so much.
Thank you
Appreciate
for all
all
your
our
work.
work.
Yeah.
Well, one further thing is, I'm just the compiler. All that work was due to residents of this village who over many, many years worked so hard on this. So I pulled it all together, but I can't take credit for it all. It's other people who worked so hard to do it. So they deserve it. And actually, I just want to also, I said in my letter, my note, but Larry and his staff have been very helpful to me in helping to get some of this material, and I really appreciate it. It's really, really gracious. So thank you.
Great.
So Chet, did you have the same stuff for me here?
Yeah.
I was just going to say, it seems relatively like a no-brainer from my perspective, but at the same time, I'd like to, when we get into the discussion, I'd like to better understand what the possible downsides
Sure.
are and just see what the trade-offs are. 'Cause,
Absolutely.
I know once it becomes parkland, it's kind of inalienable at that point.
Right.
So, or very difficult to alienate it. Free it. Yeah.
To read it. Any public comment?
on,
Or we can wait for the actual, I think you're here for the defensive indemnification law.
that's correct.
Yeah, so we'll wait for that. Not something, not on
Is this, I thought.
I think this would be a good opportunity.
Yeah, okay. My name's Randall Shepherd, and I'm here to talk about a traffic condition in Irvington. This is Main Street, the railroad tracks, Astor and Buckout, down at the very bottom. And, okay, and I live here, right on this corner, at Buckout and Main. And I've lived there for 9 years. And whether the windows are closed or they're open, this is the angriest intersection in Irvington. I hear more road rage. I've seen fender benders happening in here, and it's due to, here we go. So, at Main Street, you're going north, and you have parked cars all the way to the corner, up at the top. When a car comes on Buckout and wants to take a right, they cannot see oncoming traffic until they stick their nose halfway out into the street. A lot of people don't stop. They just go sailing through there, and this guy gets cut off, and he's angry. I've heard road rage guys go chasing up after cars up the street, the guy with his car chasing another car, to the extent that pedestrians along the sidewalks were going, hey, hey, take it easy. I mean, it's like, oh, geez. And here's, given a little thought about this, I think the solution lies right here. That car, this car right here that parks right up at the top, is killing the line of sight. It's like, if you can only see from here, if you, with the car parked here, without the car there,
Absolutely.
you then open a lot. I don't think a stop sign here that's useless. These guys coming out of the train at 5:33 isn't there? A light is like a no starter. But, okay, this, it has a downside. We're eliminating a parking spot, my parking spot. However, on Buckout, here, right in here is a no parking zone. It's painted off with yellow stripes. And a house down here just reopened a driveway that's been closed for years and years and years. And so it was continuous parking from the corner down here to where people had driveways. That has broken up the parking in here. More to the point, that's too complicated, but if you moved the border of this no parking zone right here, just 4 feet, and mark the parking spaces. None of the parking spaces along this strip are marked. So if you've got room for 5 cars, 3 people can kill it all. Just no problem at all. So if they were marked, that would be good. But also a little of this, it would be insignificant if you took a little of this. It has nothing to do with the line of sight, has nothing to do with, it's nothing. But, well,
I think it's clear. I think what we'll do is we'll ask Larry and the chief, the police chief, to take a look at it. Anyone who comes with a visual aid gets an immediate answer. So, I think this is a fairly clear. I mean, I think everyone on this board knows
We've all been
that.
there.
yeah, it's not like you have to do a study. You just gotta drive through it,
Yeah,
you know?
And we
it's-
all do that stick your nose out thing.
And it's always coming up and going across. It's just those 2 characters that get into, horns honking all the time. I hear it, oh, yeah, there goes one. Oh, honk, honk. And they start leaning on the horn and they really get, angry.
Very good. So we'll take a look at that.
Sure.
Randall, I was just going to ask you, we've considered over some period of time perhaps making that a one-way street,
Buckout. That one's okay.
Buckout.
that part of Buckout a one-way street.
going,
Well, that's what I was going to ask you. That's what I was going to ask you. Which way would you want it to go?
so that means Buckout would split at
Yeah.
that point.
Which way would you think it should go? Which direction?
It's a citizen power.
Well, I'm just curious.
I hadn't thought about one way. I think village habits are going to be awfully hard to break in that way. I mean, like, people are going to, well, all of Buckout could be made run one way because the whole thing is too narrow from beginning to end.
And that's why there's no parking at the top, because you need to pull over if there are people
Yeah,
coming.
it's how do you?
Well, yes, but it's not that much space, that little, that we could use to create the other parking space. If you didn't care about the zero sum with the parking spaces, then I lose my parking spot. I'll have to move to Tarrytown or something.
There's endless.
We'll find you a spot, really.
There have been some suggestions about some of those corner spots being compact cars only. I'm not sure if that would help in this situation.
Motorcycle parking.
Possible.
Or one of the bike racks to get.
It's,
I've sat at that corner many times, trying to just weigh the odds about how far should I pull out versus the risk, and it got to the point that I actually end up looking all the way down to Astor Street, to the corner, to try to judge how much.
And in that amount of time, somebody's come down Main, and you've got to, if you make a move going up, all of a sudden you've got
But what I was
something.
gonna
And you
say
don't
is-
see the pedestrian walking down
Oh, well.
in the other direction.
They're on the road.
Yeah, they're on their own. So
Yeah, no,
the
and
thing
it's
is,
a crosswalk right there.
the thing is, I got to just say is that my experience is that, and I'm glad that you brought this up, so don't take this wrong. I think more than one parking space has to be lost to give you visibility. I don't believe it's just the one that gives it to you. Just based on my experience, maybe I have too low of a car. I'm not in a big SUV that can look over the hood. So
That's a problem, because you're looking downhill and big, tall things. You cannot see anything unless it's all the way down to the bottom of Main. It's,
I've counted at least, I've estimated at least the first couple of spots would have to come under the parking zone. Yes, I know, yep. And now you'll have to move out of the state
well,
because
there's that empty lot in between 16 and going down
private property,
that we could open up and make a parking lot there.
If we owned it.
My
Yeah,
landlord.
consider it.
No, my landlord might be interested in perhaps a big parking garage at like $12 an hour or something. Anyway, I'll be quiet.
Maybe we start with one and see how it works.
Okay.
Great. Any other public comment? Yeah, preferably with some kind of visual aid.
yeah.
Can I bring a visual aid for coming out of South Paris Street for 40 years and having to stick your car out? Okay, I'm gonna do that.
All you have to do
It's
is
it's a very
you just have
similar,
to change the names of the streets.
yeah, it's exactly
And
the
instead of roads,
same
like a sidewalk or
situation. To stick your neck out, and if your car isn't as high as
Yeah,
others,
I would say-
you have the same thing.
I
The
did say they
parking,
was backing out of the other side of the street too, sorry. but-
anyway,
Is that legible, man?
the perils of living.
So, as soon as there's no other public comments. Thank you. Consent agenda, anyone have any questions on the minutes?
You want to take a picture?
I hope you read them carefully, to see what you got submitted.
Yeah, we missed yours.
Well, when I heard the entire meeting was like 15 minutes or whatever, I was gonna do something wrong.
I bet you chimed in on your watch it online. huh?
Exactly, live, of course. So I'll make a motion to approve the minutes of the village board. If you consent agenda, it's easier to say. If I can get a
Oh,
second.
yeah, great, you can,
All in favor?
Aye.
Perfect. Next, I'll make a motion to open the public hearing, to consider a local law amending chapter 19, defense and indemnification of the village code. Can I have a second?
Second.
All in favor?
aye.
Public hearing is now open. All right, do you want to give us a quick overview?
It's not here.
I always say quick, I don't know why.
Yeah, I know,
I usually say 2 seconds or something. 2
I
seconds.
know, I know, but, okay.
That's only when we announce
It's
it.
not a big deal, but it's kind of hard to explain. The point of this amendment is to eliminate confusion that currently exists in the defense and indemnification law. Mostly, and I'll get to one exception, it doesn't really change the law. But if you just look at the language of the law, it's confusing. Essentially, though, what the defense and indemnification law does is to provide that a village employee, and that includes board members and volunteers, if if an employee is sued for something he did or didn't do or she didn't do while working, or the village will provide a defense for that person. And if they're charged with damages, whether it's by settlement or lawsuit, that the village will indemnify them and pay those charges. This is a provision that the state public officers law permits, and it's been part of the Irvington Code since at least 2002. I expect there was some provision before that. Now, the code currently provides, at the very end of it, and I'm going to the end first, you'll see why, is that all substantive benefits provided by the New York State Public Officers Law are conferred on village employees. They wouldn't be automatically. The State Public Officers Law doesn't automatically apply to the villages unless the villages choose to adopt them. So, at the very end, there's a provision that says that substantively, not procedure-wise, all of the substantive benefits provided by the State Public Officers Law are provided to village employees. And that means that if the employee is acting within the scope of his or her duties, he or she will be entitled to defense and indemnification unless the injury results from intentional wrongdoing or recklessness. It's fine, and that's what most municipalities provide. The trick in the Irvington Code is that in both sections 19-2, which deals with the duty to defend, and 19-3, which is the duty to indemnify, says that you only get defended or indemnified if you weren't in violation of any rule or regulation of the village, town, county, or state at the time the alleged action occurred. This is a pretty big exception. And it's in both the defense provision and the indemnification provision in the language of it. However, if you go to the savings clause, the conflict provision at the end, it says if the state public officers law gives you the protection, you've got the protection. So it's meaningless. This language is meaningless and it's confusing, and so this was really aimed at just eliminating what was confusing language. You get to it if you get to the very end, but I know that in the past it has been confusing when we get to make a decision. Unfortunately, not often. So essentially, what it does is delete a meaningless provision. It doesn't change the law because the law says whatever the state provides, you have anyway. It makes two other changes to make it entirely consistent with the state public officers law, and that's to use the same term for the intentional exception. Right now, it's one of those, that throw in all the words. It says where the damage resulted from intentional wrongdoing, recklessness, maliciousness, and a gross negligence. The language of the words maliciousness and a gross negligence don't appear in the state law. But maliciousness is the same as intentional wrongdoing, and gross negligence and recklessness are the same standard. So it just makes the language the same. Then the other change it makes, which is somewhat more, as it turns out, more controversial, is that and this is a change. Right now, the code has a provision that says that. I won't read the whole thing, but that the village can indemnify for punitive damages in certain circumstances. Now, the circumstances are so narrow that it's hard to imagine how punitive damages could be awarded if all of those standards are met. So this also recommends taking out, that's part of the one, to take out that provision. Anyway, and I think you'll hear about that. I don't think that's huge. I mean, that was not sort of the purpose of the amendment, but when we were going through, we said, clean it up, and we'll make it just like the state law. Now, the state law doesn't provide, this has what is the state law provision for punitive damages, but you can decide separately how you want to handle punitive damages, which is the way the code does now. Remember, whichever gives more relief to the employee is what applies. Okay?
Can you just go through that one more time? No, the last part, no, of course not, the last part. I just want to be sure I understand what you're saying.
Yeah, the punitive
You took-
damages
You
part.
took out the punitive damages
Is that
that
the
were
section
specific to
here?
the village?
Section 3.
Yes.
Section
It is.
C,
Yeah, but in the Irvington Code, there's a provision that says, "The village shall also indemnify and save harmless its employees in the amount of any punitive damages and upon the following findings." And that is that the judgment of punitive damages is based on an act or omission of an employee acting within the scope of his employment or her employment. At the time of the action, the employee acted without recklessness, maliciousness, without gross negligence, or otherwise within the standards required for employees holding comparable positions. So it's hard to
Imagine what
see,
kind of punitive damages if you didn't.
yeah, if you met, how punitive damages would be awarded if you were acting without recklessness, maliciousness, or whatever.
So that section comes out.
Well, the way it's drafted.
Yes, and that's
that whole
something-
thing will
yes,
come out,
right.
because it doesn't,
It doesn't make sense.
well,
Or,
according to the police, it makes some sense, and maybe they'll be able to give some examples of when punitive damages would be awarded under these circumstances. But the truth is, if you left it in my opinion, if you left that in there, it's not gonna make a big difference anyway.
okay,
I mean,
so,
except you could say if there was a horrendous decision in a court that,
Right,
which is,
Known to have happened.
yeah, especially when you have a jury. So, that would be the first one that pops in my head. You just had a terrible decision, which I think is
right,
bad on.
right.
So,
But, yeah, and if that's the case, you would only, you would be providing indemnification if they acted without maliciousness, recklessness within the scope of it. So the point is, I think, as you may recall, that wasn't one of my
The original reasons we were changing this, yeah.
recommendations, yeah. I didn't think it made a big difference if you wanted to take it out, but I also don't think it's a problem to leave it in.
yeah, that's what I mean, I think before we, take a lot, I mean, we definitely want to hear from you, but if, to me, I don't see a lot of downside to the building,
Yeah.
but I think.
I don't either. And so then what you would do was unsubstitute, just leave this alone and take the, what we substituted was the state law provision on punitive.
right, can you explain C then, a little bit?
What?
Can you explain C, the insertion?
The new insertion.
Yeah, well, let me see, nothing shall authorize the village to indemnify or save harmless an employee with respect to punitive or exemplary damages. Covered from an employee pursuant to General Municipal Law 51. I looked that up, now, I did check that out with 51 was, but I don't recall it right now. Provided, however, that the village shall indemnify and save harmless its employees in the amount of any costs, attorney's fees, damages, fine, and penalties, that may be imposed by reason of an adjudication that they violated some federal order, so that's actually put in yellow. What I did was I took the state provision and put it in there.
So they can't be indemnified if they violated a state court or U.S. court or federal order? Is that what, it seems to be what?
No,
Consent decree or stipulation of settlement in any New York State court or court of the United States.
violated a
no,
prior order.
that the village shall indemnify. If what they did was violate a prior order, judgment, consent decree, or stipulation of settlement entered in any New York State. To tell you the truth, I never understood that provision. It's the state provision, we decided to put it in to make it all consistent. And I don't, if what you're gonna do is just leave our provision in, which I think makes more sense, then you don't have a change.
Before we get,
No,
maybe
no,
if we could just step back from the language, which is a little convoluted.
Yeah.
And to get to what our intent is, because I think the issue is how extensively do we want to cover in the event of the possibility of punitive or exemplary damages.
Right.
So one approach is to say, well, we'll cover for anything that's within the scope of employment, but we're not going to cover for punities. But the other is to say, we will indemnify and cover our employees unless it's like, unless whatever.
Yeah, well, right now, what we've got in the code is that we'll provide indemnification for punitive damages if it was within the scope of employment, and it wasn't reckless or malicious. That's what the
That's what we
provision
had.
is now.
That seems pretty common sense.
Yeah.
Yeah.
And then the employee had to be acted in good faith and not violate any.
To me, again, it seems like it's only if you have a jury that just says,
Yeah,
even though he was in his, scope of his employment, I just don't like him, so we're gonna give him punitive damages, and then we say, we should probably cover that guy because he did all those other things.
yeah.
Sorry, I almost knocked you in the face.
Punitive damages.
We can deal with that.
But, that's my take on it. I mean, you guys might have other examples as well, but to me, bad juries are something that.
Yeah, I suppose you could think of a situation where maybe they could persuade the village that it was done for, with racial animus or something. They persuaded the jury. But you guys look at it and you really don't think it was. You think the guy was just, perceived things wrong or something. And then, so maybe the jury awards the punitive damages. If you could look and say it was, well, in the scope of employment, he or she was acting in good faith, and they weren't acting with recklessness or maliciousness, and they weren't violating a clearly established provision of law.
I feel like
So that's
C,
one example I could think of.
I just read C for the 5th time, and now I finally get what it's saying. I think it's pretty opaque. I mean,
Yeah, it is.
I would rather have, if it's equivalent, I'd rather have the village's original language.
Yeah, I don't think it's equivalent. I don't think that state provision is equivalent. I think that, it's the state law. We decided we would, mirror the state law, and so we took the state law punitive provision. I think it's fine to keep the one that's currently in the law. I don't think the village runs a big risk on it.
So could I
And then also, it avoids what the issue that the police department raised about taking away a protection that they currently have, and then it comes
Well,
to
maybe
you.
we should hear from them.
Could I just ask a simple thing here? Of the 2 pages we're looking at, we have local law, page 1 and page 2. So I understand the state provision, that's C, that we're thinking maybe we won't do that, or,
Right.
that was proposed. But where is the part that was stricken that we're
It's section
talking?
3, Connie.
It says it's hereby
Section
deleted.
19, for
so it does not-
punitive damages.
So where is it? So what is the language? So we,
That's what she.
That's what I've been reading.
well, we don't see it.
We don't see it.
Okay,
Right,
okay.
right, it just
We
says
don't
the whole
physically see
section's
it.
deleted, yeah.
Okay. I was looking for
Yeah.
reading what you were
No,
reading.
No, sometimes if you were saying that the code is amended to read like this, and then you put the whole thing and you cross it out, but I just did it that
Okay. All right,
It's
thank
not
you.
there, no doubt.
Okay, it's not there.
way. There's no page 3.
Okay, thank you.
Does anyone else have questions here? Otherwise, maybe we'll turn it over to you guys, if we haven't already got it.
Well, thank you. My name is Keith Byron. I'm an attorney for the PBA. And I've been taking a look at the local law. As you may be aware, I've written a few short emails to council on that. I have a couple of concerns. One is, I understand from listening to the village attorney tonight that what your aim is, which is to bring you into clearer compliance with the provisions of the Public Officers Law. I think it's 17 and 18. What it was is the state passed a defense and indemnity for their own employees, and they said, well, we're going to do this, but we're not going to make you do that. So the next law says, but if you want to, go ahead. So that's pretty much where we are under the Public Officers Law. But what you need to be aware of is, and I'm going to speak primarily about the police, your obligation to provide defense and indemnity to the police officers as opposed to your other employees or to each other is governed by General Municipal Law, Section 50J. And that's completely independent of the defense and indemnity provisions of the Public Officers Law. And basically what it says is, notwithstanding anything you do, I mean, I don't mean to minimize it here, but that's what it says, notwithstanding any state or local law, you have an obligation to defend for tort claims against your police officers. So to the extent, and I can read it if...
I've got it.
Okay. I mean, it's pretty clear on that, and that's one. And your limitations on recklessness, I think, would fail. I think it's there now. You know what I mean? That the law doesn't propose to change that. I mean, counsel's correct. The current defense and indemnity provisions of your code do not provide coverage for reckless behavior, or reckless conduct, excuse me. However, I think that's in conflict with 50J of the General Municipal Law, and therefore probably is not enforceable. So you might want to think about it. I mean, at least, sit and figure out how this shakes out with your law. And I want to come back to that. 50J also says that in addition to this general defense and indemnity, which you're obligated to do, you can't jettison it in your own local law. It says, in addition to the requirements of subdivision 1, upon discretionary adoption of a local law, you can provide defense and indemnity for punitive damages and buy insurance for that. Mr. Mayor, I think you hit this right on the head. I've been doing municipal work like this for about 30 years, a little more than 30 years. Most of it was as an assistant county attorney, defending public officers, excuse me. And in that period of time, we had two cases where we were absolutely appropriately, under the circumstance, and punitive damages were awarded. I mean, I can't tell you the extent to which we were gobsmacked and blindsided by this. I mean, it just came out of nowhere, like we were expecting a defense verdict, but now we're going to get that. We got punitive damages. So what your local law gives you the option of, in reality, is to sit there in an executive session and look and say, Jane did everything right. I disagree with the fundamental findings of the jury in this case, and we want to provide defense. We don't want her family to have to bear the brunt of this. So when you take this provision out that you currently have, you're just denying yourself this option. And I think that's a mistake, because while certain say, they've been telling us about him for years, we should have taken action, this is a punitive damage, we have to pay money, but if there's punitive damages, we're not going to do it. But you sit there and you make an informed decision on what you believe the truth of the matter is. And then you make a decision on that. That is a better way to proceed than just saying, hey, my hands are tied, I don't think you did anything wrong, but I guess you have to sell the house. Yeah, that's it. And that's not right. Okay, so I would urge you not to remove subdivision 4, which is your punitive damage authorization. And you might want to look at it to tweak it a little bit, to meet whatever you think the appropriate standards are, or to give you sufficient latitude in order to make what you would think to be an informed and correct decision. Now, coming back to another law, and this is not council's amendment that I'm addressing now, but since you're talking about the law, this might be an opportunity to address this concern. As I said, 50J makes no distinction for reckless conduct. You still have to defend and indemnify for reckless conduct. That's my reading of it.
Okay, I'm
Okay.
not sure that's a fair reading, because it specifically uses negligence.
All right. Here's the problem that you're going to run into, okay? Here's how I know that I don't know anything. This is why I think I'm right. okay? Vehicle and traffic law provides specific immunities and exemptions from rules of the road and standards of conduct, okay? In other words, if I or you or I go out and we get into an accident, we're sued for negligence. Your police officer is acting in an emergency mode, I'm most concerned about, cannot be sued for negligence. That's not permissible under the law. The only thing they can be sued for is reckless disregard for the safety of others. So it's a reckless standard. Every attorney who's going to sue your police officers knows this. It's not a secret. It's right in the vehicle and traffic law. Cases are legion on this point. So therefore, your police officers are going to be sued for recklessness. Your local law says you don't provide defense and indemnity for that because it's reckless. If there is a verdict, that verdict will only be for recklessness. It will never be for the lower standard, because the lower standard, any claim for that would be dismissed because that's not the law. And I would just address your attention to vehicle and traffic law sections 1103 and 1104. And I have copies with me if you'd like to see it. If not, counsel can provide you copies of this.
It only pertains to driving.
Okay, and your local law pertains to driving too, though, right? I mean, it's a Venn diagram, so
I'm just
part of
saying.
it is,
Okay.
right? I mean,
No. All I'm saying is what their point is just.
correct. No, that's all. Yes, I am painting with a narrower brush than your local law, which paints with a very broad brush, which includes these types of issues. In other words, counsel's correct. I mean, there are other circumstances under which you'd have your officers sued for reckless conduct. I think you probably want to cover them for that because these are just mere allegations, rather than saying just because plaintiff's counsel has drafted the complaint in a certain way, you may be on your own. Maybe
Defended. You get defended. It's just you don't get indemnified.
I would just be careful about this. I mean, you will never have a verdict for an automobile accident with these people in emergency mode. Never. That isn't reckless. You just won't, because that's the legal standard they're held to. Anything below that is negligence, and negligence cannot form the basis of a lawsuit.
It has to be reckless.
It has to be.
Yeah.
And you're exempting this as part of this law, and I think that's a mistake. And just to further on this point, because it concerns me, because I was on the other side and I see lawsuits, your DPW workers who are working on the roads, snow plowing, paving, whatever they're doing, a standard of recklessness in order to sue them. So you'd be cutting them out too. Probably firefighters.
My question is, if someone was truly acting recklessly, whoever they are, again, we defend them, but we don't necessarily indemnify them. And do you want to always indemnify recklessness? I mean,
The answer is that how best to put this? Juries are going to do what juries do, and plaintiffs' attorneys are only going to, whether it's negligence or not negligence, they're going to say, no, it's recklessness. This is what they did, and we're pleading this as reckless. If it goes to the jury, and the jury says, poor family's injured. You know what I mean? You're telling me I can't award damages? The kid's injured. And you get this, it's a sympathy factor. You're going to get verdicts you probably already have, right? You probably already have. They've just been covered by insurance, right? Because your insurance carrier is going to cover all these claims. We're really only talking about either a claim for which you will find yourself without insurance for whatever reason, or you've burned through your layers of coverage. Unless you're self-insured, I don't, you could be.
We're not.
Okay.
I have a question, because this is naivete, I'm sure, because I don't think about this at all very much. The way I was reading A and B was that this was almost like a backstop. Is it that when you have something like a finding that of negligence, or is that the court finding, the jury finding, or is that a finding that the village makes on its own, i.e. the trustees and the council makes after having whatever is going on in court, whatever has
It could
occurred?
have been in court, but maybe if it's a settlement, it's not, if you.
Well, I guess what I'm saying is what happens if, the example where we said, well, we really didn't think that that was a reasonable decision by the jury. So does that mean that there's a fallback?
We can't do anything? Yeah.
Yeah, does that mean there's a fallback for the Board of Trustees or is there no, and the village, or is there no fallback? It's always whatever the court finding is, period. Because the core of your argument, if I'm understanding it, is the court's finding is the court finding and that's it. There's
The way
no
the court,
discretion by the village.
Just, can I just back up just
Yeah.
to your point, because if it's a settlement, it's not a court finding. It means the parties agreed between themselves, so then none of this should come. So,
what I'm talking about.
but I thought that was in your list, but so we're really just talking about if there's a jury finding, or if it's a bench trial, if there's a court finding of, that rises to that standard of recklessness, or
Our hands completely tied.
our hands completely tied.
Right, and that's what because from listening to what you're saying, I thought the intention of this was to give the village a backstop. And this, if it doesn't,
I'm not sure what you mean by give it a big stump.
that we could say, in fact, we could authorize the indemnification or the payment of fees.
Where there's recklessness, no. That was never a purpose of this change. That wasn't the law before, and this didn't propose
So it's
to
whatever
change
the
that.
court-
If you want to change it, you can, but the only point of this, before we got into the punitive
No, I'm
damages,
talking, but hold it,
is to
stop for a
take out
second.
that meaningless
Right, I'm talking
language.
about the example where Brian was brought up, where we thought that the decision for punitive damages or whatever didn't make any sense, and therefore we had an option not to go ahead and.
It would give us political cover because of all of our losses, we don't have to
It
back
goes
them.
on the punitive, but let's say punitive damages weren't awarded.
Yeah.
But the jury found that, that there was intentional wrongdoing. That was the court finding. And you guys didn't really think it was intentional. Well, under this, you wouldn't indemnify.
But even if we
But
said,
that's the law the way it is
but even if we
now.
said we wanted to, like, we think it's a
No,
terrible
you can
decision.
change it. You can change the law to provide more coverage if you want to.
No, I'm just saying, under the way,
It's in your
under the
choice.
way it's currently written, if we say it's just a horrible jury decision, and we want to indemnify them, we can't. It ties our
I
hands
don't
to
want to
it.
be in that position, where we can't
Yeah,
indemnify
it doesn't
our
make sense,
people
For a terrible jury decision.
for a terrible jury
But
decision.
Whether it's a punitive or a wrongdoing
Any-
decision. I thought that's where
Or-
we were going with this,
the,
or where we were with it, sorry.
where you- if I could just, I mean, this, it's being changed. The change that I don't like is the removal of the punitive damages. The other changes, I think she's right. I think counsel's correct. It's better. But the law itself has flawed, okay? Now, you don't want to take away punitive damages because, the chance, because first of all, you do have runaway juries, and you want to at least have the option of looking at it. And that's all this law, that's all that's authorized by 50J, and which was incorporated at least in sum and substance into the code in 19-4. And that should remain. So it should come to you and you look at it and you know the people, you get a basic idea of what happened, and either you agree or you don't agree, but it's your call on that. With other concerns with regard to reckless behavior right, or the exclusion for that, that is currently in the law. That is not a product of council's changes. That's the way it's written now. And I'm telling you, I think that there's a problem with that, because the legal standard for vehicle and traffic law, the only thing you can be sued successfully for is reckless behavior. So therefore, you would be excluding from defense and indemnity
Any vehicular.
any of them, all of them. And that's a terrible position to be in for the guy plowing the truck, plowing the roads with the truck, or because he's on the same standard. He can't be sued unless the allegation is that he acted with reckless disregard for the safety of others.
Just to be clear, so if your suggestions, if we decide to incorporate, I'm sorry, let me start that sentence again. If there's an award of punitive damages, it may be that we take a look at it and say, this is pretty horrible. He backed the car over and then he went forward and he backed it over 3 more times. So really, that's fair. That's reasonable. But we don't want to give up the opportunity of reviewing it and looking at it.
So what I'd say is, when you read 19.4, it's, as it's currently written, it envisions that you will make an inquiry into certain of the facts in an executive session and make a determination. That is how, that would give you the opportunity.
Do you mean for punitive damage?
For punitive damages,
All we're
yes.
talking about is punitive
Right,
damages.
so,
Yeah, no.
No, we have the bigger statement.
The bigger issue
one
is the
about-
recklessness.
Yes, reckless, indemnifying reckless.
Because that's the standard, that's the only way the damages can be brought.
at a minimum, you should defend and indemnify employees who are covered, who are in the scope of their employment, right? And covered by 1103 and 1104. And that's a vehicle and traffic. That has nothing to do with somebody discharging firearms. It has nothing to do with anything other than vehicle and traffic law.
What happens if we were to find that the employee, whether police or DPW, whatever, was, under the influence of drugs or alcohol at the time, so that the incident occurred? So that would be,
The interesting thing about, you gotta, what lawyers do, plaintiff's lawyer, but what plaintiff's lawyers do is we sue everybody and we let God sort it out later. I mean, it's sort of, so you're getting sued. It's not just the employee getting sued. So if you had an employee who was drunk, you're getting sued because you failed to recognize it, you had negligent hiring, you had negligent supervision, it's all your fault. I don't know, that's what plaintiffs do. Everybody's, and the mayor knew or should have known, and the village administrator knew or should have known, and the department head knew, and pretty loose, you read the whole thing, and it's like everybody knew.
no, you're getting me a little bit wrong on this. I'm thinking if it's back to,
If someone actually was reckless.
was reckless and,
Yes, I mean, I think there's times when you don't necessarily want to indemnify someone who was reckless.
I don't think that is,
I can make up
I don't know that, I mean, obviously, there's this again is a very large, the field of tort, okay? So, would that constitute recklessness on the part of the individual?
most certainly.
I don't know.
think anyone-
No, I don't know that. I think there's
Would say
Well, let's
that.
do something even more.
it's a statutory violation.
So there's an automatic alarm that they went to 36 times that day. They drove 120 miles an hour down a one-way street, and they hit a child. You can probably make the case that was reckless, because they didn't know they needed to go on 120. They had been there 9 times before they knew it was a false alarm. I mean, you can make up some reckless thing. I don't think we want to say we have to identify everyone that was reckless. I think we want to say we have the option to consider it.
And understanding that the reckless standard is the only one that can be applied, because I think we're listing a couple of things here. If I'm hearing you correctly, recklessness is a standard that applies for B&T.
Correct.
That's the word that's going to be used in any
Reckless disregard for the safety.
negligence in another context is going to be considered reckless disregard in B&T as it applies to the police.
It would be pled that way.
It would be pled that way, okay. Okay.
And, you know, I think that you should also think about the message, and, you know, this is a hard to put it this way, but I'll just throw it out there. You should think twice before your defense and indemnity provisions are more narrow than the insurance you buy. You know what I mean? Because that means, what does that mean for your employees? What's the message I'm to take from that? You know, you're covering yourself, but you don't want to cover me?
No, I don't think that's what we're saying at all. I think that there's a concern that there may actually be reckless behavior that comes through, like, stick with the drug thing for a minute. What about if someone's been operating, it's so hard to talk about this because people are watching. I don't want to get any bad vibes from the DPW, for instance, because they do a great job, but they're all night plowing, icing, de-icing, whatever. Someone's been, you know, taking amphetamines. Does it happen? I don't know if it happens in Irvington. Has it happened elsewhere? I'm sure it's happened elsewhere around the state. So with long hours and lots of snow and, you know, blizzard-type conditions. So at that point, there's an accident. Now, you happen to find out, it comes out in the testimony or whatever, medical reports, that the person was, you know, fairly high on some sort of amphetamine. At that point, wouldn't that be a factor that you'd want to consider as a village?
See, I think, I mean, I'm not really here to speak on behalf of the
I'm not,
DPW people.
I didn't mean,
but I
I'm
will
not
tell you-
pointing fingers at
But I
DPW
will tell you this, they are a very elaborate scheme of drug testing on a random basis because they have CDL licenses, and so you guys are actually on top of your game there, so you have actually very little to worry in that, generally in that area, but.
And you would say the same thing about substance abuse testing for the police.
Well, I can't because they're not covered by the federal Motor Carrier Safety Act, you know, so.
I think to boil this down to the heart of the question, I think we want to give ourselves the opportunity to consider all the facts ourselves, or do you want to kind of give away the opportunity if it's reckless for B&T or something like that? And I think that's, to me, the common sense thing is you want to give yourself that relief valve, or for, 99 times out of 100 where someone was reckless, there might be that one time where we don't consider it reckless, and it's obvious to everyone. So I think it would have to be a pretty high standard that, they said, well, they didn't have their front dashboard light on, so that was reckless, and the jury says, I agree, because they don't like cops or whatever. I think
that you just said a really important thing, and let's not be naive here. There are lots of verdicts that are anti-police for just that reason.
Absolutely.
And I think that everybody should be held accountable, but I also think that we have to recognize the reality of life and juries.
Yeah.
And I would be very loath to not have the opportunity
review it ourselves,
to review those kinds of judgments.
Yeah. I think, again, 99 times out of 100, if someone was reckless, we're probably not going to want to indemnify them, but where there's something that's so obvious that, we look at it and say that this doesn't make any sense, to not give ourselves the right to identify that person doesn't make sense to me.
I think you'd find, and I don't want to debate because I'm not here with statistics, but I think it's actually the other way around. Most of the cases, because they're V&T cases and they have to be pled to recklessness to that standard, most of them you would want to cover because you'd say, I don't think that was reckless.
Right, well,
You know what I mean? I just had to find that in order to give them money.
Outside of V&T, most recklessness you don't want to ever indemnify. So to say like, well, recklessness, we'll just indemnify anyone who's reckless,
Yeah, we're not
as long as they
saying that.
didn't commit murder, you know, like it's,
Right.
but I'm saying that, you know, even, you know, and you could definitely come up with scenarios where there was reckless driving that you might not want to indemnify, even if it was, you know, performance of their duties, but I think that that's where I'm coming down on this, Mary Ann.
I think we all agree with you.
Yeah.
So I,
Maybe.
separate from that, if I go back to our original discussion about this, and correct me if I'm wrong, but I thought we were simply making this consistent with the state law. So are the problems that we're discussing now still, are they part of, is that a problem within the state law too?
No, because you can provide, I mean, the state law does not provide indemnification for recklessness, so it would be different from the state law.
Okay.
But you can provide whatever you want to. You can provide a lot more than the state provides. The only thing is, if there's a conflict between what the state provides and what the village
You get more.
provides,
You get more.
you get the greater.
So does the state law preclude coverage recklessness? No, so
It
we're not,
doesn't provide it, but you can provide it.
okay, so it doesn't preclude it, so we're not establishing a standard contrary to the state law, we're just being more,
No, I don't think so, but I would,
So-
obviously confirm that.
So across the state, of the municipalities that simply use the state law, is that the most common thing?
Well, and the ones I looked at, yeah, I mean, I looked at, I started looking at them because to find out whether the other municipalities required that they not be in violation of the local law, of state or local law. I was surprised to find that nobody had that, in fact, but it varies tremendously. It varies tremendously. I would say if you have the one that's the most common is the village provides the same protection that the public officers law provides.
So that would,
Right, but it's all over the law. It's really all over the law.
so that would preclude the situation that we're talking about now. That it would,
Right.
right.
To me,
So that's
to me, it's
a
almost
discussion
taking
to
the
have.
state law and saying, this is our law, but we reserve the right to review and take the individual case, you know, it's.
And just, I mean, one of the things you need to remember in all this is that before the state passed the provisions of the Public Officers Law, there was no statutory obligation or really authority for you to defend and indemnify your DPW workers, your clerical workers, and you know, your village administrator. There was an obligation to defend and indemnify the police, and that is separate and apart from this. So, and that law says that if there's that notwithstanding any law that you pass. So I would only, my point here is, with this, is that with respect to your defense and indemnification for recklessness, it is not clear to me that that would not be in conflict with subdivision 1 of 50J, which just speaks in terms of torts. And recklessness is a tort. The conflict for the police comes in the changes with respect to punitive damages, which are expressly you were expressly authorized to address in paragraph 6 of 50J, but yet there's no such corresponding language for non-police officials. So, I mean, that's, I don't mean to confuse it, but that's, you know, when you talk about, you know, we want to bring into compliance, law is separate and apart.
That was not the point. That was not the point, was to bring it in compliance with the state law. The point was to eliminate the confusing language.
inconsistent language.
Within our own.
This is, I mean, it's fine if you want to go beyond, but just to understand this is
Right.
going way beyond. And the point of this was not to bring it in line with state law, it was to eliminate what was confusing language, because it already said if it's between what the state provides and the village, if the state provides more, then you get them greater coverage.
So we took out the stuff that specified what the village would do, because in the law as it was written, the final provision said, except if the state gives you more, in which case you get more. And it was like, okay, so why do we need all the other stuff in front of that? So that was the whole point of this, to make it clearer and streamlined. But certainly it was not our intent to give up, I don't think, the right to review this.
Okay, and that was my main, that's the change in the, here on, and I just put my 2 cents in on your reckless standard, because
2
that's
cents,
just,
50 cents maybe.
you know, and.
Got a good rate, Mike. You only 2 cents, right?
And you know, I think I've made my points with respect to anything else, so, thank you. Thank you very much for
Thank you,
your
guys.
time.
Any other public comment?
So what action are we taking? Do we have to close the public hearing, or are we?
Yeah, we probably keep it open
Yeah,
and get a revised law.
Yeah. So do we need to give,
Keep it open, yeah.
do we need to give specific guidance to?
If I understood what you wanted to do was indemnify for recklessness, vehicle recklessness. If you go through and maybe very similar to the factors you consider under punitive damages. You can award punitive damages if blah, 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 although it doesn't exactly work because it says if you find there was no recklessness, and there was recklessness. But I think if I understood correctly, that's what the board wanted, at least several of you wanted.
Ability to review, to make a decision, rather than have it in terms of recklessness. Well, I think that's what we were talking about, yes.
Wait.
Go ahead.
No, can we get copies of the various provisions that we're talking about here?
Yeah.
Yeah, because I'd like to see some of the language of that 50 whatever.
50J?
50J.
I'll provide that to
I have
council,
it. Okay.
you know,
It's
since
Thanks.
just printed off Westlaw.
Yeah. Here, Janice, I'm over.
Yeah, I think that's what, I mean, I think we, that the punitive damages will leave as is already
Right.
currently drafted.
Oh, this is just one copy?
Yeah, oh, I'm sorry. Yeah, that's the other machine. Fine.
You want to give that to Brenda, and she can scan it and get this?
And the stuff about the 50J, how does that impact what we're saying in our own law? Is there an impact?
I don't agree that the 50J protects for recklessness. It just talks about negligence. I mean, it really uses, it doesn't talk about tort liability, it talks about negligence, so I don't think it deals with recklessness.
But we can figure that out. But I think we don't want to give up our, kind of our right, our opportunity to right or wrong that was handed down by the courts.
Right.
I think that's the
Right.
bottom line.
Right, that we don't want to be, right, exactly.
Forced into doing nothing when we think we should be.
Exactly. Like everyone says, everyone says obviously he didn't do anything wrong, but we had a terrible jury, and now we're, we can't do
But
it.
more likely, what we'd be saying isn't that something terrible didn't happen.
Yes,
Circumstances of the
exactly
time
right.
and the judgment exercise,
Exactly right.
that you don't want somebody penalized with punitive damages for making a professional judgment in really tough circumstances.
Yep. I mean, the punitive thing I think we're on, but I think the right to say that we don't think it was reckless because, again, the front dashboard light wasn't on, but all the other lights were
Wait a
on.
minute, wait a minute. I'm looking at the 1104 on the vehicle and traffic lights. Driver of an authorized emergency vehicle. It never mentions recklessness. It says you could go past a red signal, exceed the maximum speed limits, disregard regulations. There is no, so the thing is, if you can do that, then you wouldn't be acting
Doesn't it at
reckless.
the end say nothing in this section shall relieve the obligation to operate, in manner with reckless disregard for the safety of others? I think so. And just for 50J, I mean, I know we disagree, but it says,
Can I
any
just-
negligent act or tort.
Can we talk into the mic? Come on, sorry. Well, we need it for documentation purposes, so if you just want to repeat that last statement, then
I'm sorry. Just reading 50J, which I downloaded onto my phone because I gave you the copy. It specifically says any negligent act or tort. That's a quote. So, but this is not the place to have,
Right, I don't think the
that
point
type
tonight is
of-
to hash out the specific wording and how it has to be worded or said, but the principle of what we want to have the decision-making.
Yep.
yeah, we got to give Mary Ann fair time to go through, to review it in detail based on the conversation, right?
Based on what I understand, though I certainly have limited knowledge of this, as Janice and Brian particularly have explained that circumstance, I agree that we should keep that. So I'm not sure how
But
that
I'm
gets written.
assuming you're saying it
Yeah.
only is to
In those
vehicle, only in the vehicle, you only want to, I'll double check, but you only would want to indemnify for recklessness in driving.
No, why do we,
No.
no.
I don't know.
I
I don't understand, yeah, there's a lot I don't understand about this. I understand the
I think-
general
I thought
principle.
that's what
I
they
think
said.
what we want to protect against is, everyone in this room looks at it and says, there's no way that that's recklessness. The attorneys are going to sue for recklessness because, that's how it starts, and, I'm named personally, and Larry is, et cetera, et cetera. The jury comes back and says, it was reckless, and we say, oh my gosh, no one could ever think it was reckless. Now we come back
So
and they
it's
say,
broader than just the B&T.
yeah, sorry, Brenda.
I think so, I think, yeah.
Sorry, Brenda.
We can't, we're not going to indemnify you because our law says we can't, even though we
Right,
all
that's-
agree.
that's it,
We all
that's it.
agree that you didn't do anything wrong.
We don't want to be in
Sorry.
the
So that, I just want to ask one other question, because I know this is not this question. So Brian and Larry and the whole board was sued in combination with whatever event happened, DPW or police officer. So now can we pass judgment on something that we were in fact a party to? You understand the question? Did it's not-
I cannot answer all these questions now. I'll look into it and get back to you.
But you, so I'm just saying, are we doing something that would be absurd?
You're asking if we can indemnify ourselves against a
Effectively.
punitive damage award against us.
I guess I wouldn't be able to vote for indemnifying myself,
Yeah, but,
We can all vote for each other, though.
but. Yeah, exactly.
What she said.
Everyone was 4-up.
All right.
Okay.
So we're keeping the public
Hearings.
public
Public
hearing
hearings
open,
open,
and we're
correct.
gonna look into this.
I just,
Yeah,
Who knew?
Okay.
well, remember how much fun we had with the ethics law.
Yeah, yes. Okay, approval of the easement agreement for property located at the end of Perkins Road.
Thank
You
you.
guys,
Thank you
very
very
much.
much.
easement should be quick if you want to start.
Did you want me to
Yeah.
Sure.
explain what this
If you're, have your notes on the stuff.
If you remember the parcel of property that the village sold as part of at the end of Hermit's Road, somebody came in to develop it. There's a cul-de-sac that is part of the village road. The village would own it, but when they got to actually developing the plans for the house and the access to the house, it made, the easiest way to look at this drawing on here. It could avoid cutting down a lot of trees by making this T-turn configured like this instead of further up. In order, though, to have enough room for the T-turn, it would have to, the T-turn, turning area, would have to impinge a little bit on village property.
Otherwise, they'd have to go up and around.
This
It
would
would
be
have
like
to
a
be
turn
configured
circle.
differently and would involve taking down more
More
trees.
trees.
I mean, it's mainly, by doing it this way, you remove fewer trees. So, and I talked to the board about it, and the board was generally comfortable with the idea. So what we have here is a draft easement agreement that says that the village would grant this easement for the purpose of installing and maintaining this T term. There's a provision that the village can terminate it on 6 months' notice if for some reason you needed that piece of property. And then the property owner would have to restore the area, I mean, I guess take up the asphalt or gravel or whatever they're using to make the T turn. It says that the work has to be performed in a good and workmanlike manner. It provides that area has to be maintained by the grantee, including snow plowing and everything. And if the village sees a problem with it, it lets the property owner know, and they've got to fix it. If not, the village can fix it and charge it to them. They've got to have insurance, a higher amount of insurance while the work is going on, and then the standard insurance. And then they have to indemnify the village for any losses there. And that's what this agreement is. It's just at this point, it still is a draft because there's not an address yet for the piece of property. And I think it'll be impossible to file and find without the address. But John Malone is representing the property owner here, and they're working on getting the address.
So,
And also, I guess we need an address for our property, for the piece that the village owns, or something, but anyway, just makes it easier.
so it's not preventing us from doing any kind of the sorts of passive recreation development if we needed to create a parking area in this area. This is.
Well, I don't know where you want to have the parking area,
Well,
but I mean, I guess.
It would be on village property, but we had talked about
I
it.
know, but if I mean, conceivably, if you had the parking lot over their part of the T-turn, it'd be a problem, because they wouldn't be able to make the turn.
No, but I'm just saying that whatever the easement agreement, it's not blocking us from doing anything else.
That little corner.
No, yeah, but unless you give them notice and terminate it, you can't do anything there, but other than that, it wouldn't affect.
Yeah, I don't know that piece of, that little end of the hammerhead was anything that was envisioned to be parking.
Yeah, my guess is it probably.
Yeah,
is
about
the other
further
way
in.
anyway.
The other thing is that, because I sat through some of the planning board discussion, I have to say that it really was, they represented, when I believe John Malone at the time represented, that it would save quite a few trees by being able to reposition the house. And it seemed like the net was much more of an environmental benefit than what the initial envisioning the cul-de-sac and the initial house placement was going to be. So I know that's what you said, but I'm just concurring.
Yeah, no.
I mean, the amount of space is, I mean, on the picture, it looks very tiny, but somewhere it says how much actual, the easement is
No, I don't know, Norman thinks.
4 feet by
Couple
a
hundred
foot and a
square
half
feet.
or something.
No, it says depicted on the drawing.
So,
1 inch is 30, so it's about, it's a triangle that's about 30 by 30
Yeah,
by,
give or take.
So that'd be 45 square feet.
okay.
30 by 30 foot, that's
Yep.
45 square feet.
that's not very much.
Good work, Mary Ann.
I think it's all right.
This is good.
Resolved to approve the easement agreement for the property located at the end of Hermis Road, tax designation of 2.1010-58-4.1, and authorize the village administrator and village attorney to execute said agreement. Any additional documents necessary to complete said transaction, I'll make a motion. Can I have a second?
Second.
All in favor? Aye. Acceptance of a draft generic environmental hearing for the comprehensive plan update.
Yep.
Have we had a discussion about this, or I think it's an exciting step, that's all I'll say.
I mean, all the work is, there's a lot of the work is done, and this is just saying,
Well,
here it is.
I have 2 comments if we're taking comments.
Sure.
Are we taking comments, Marion?
Yeah.
What? Yeah, yeah.
It's your resolution.
Yeah, okay. I don't know these I don't know how substantive they are in terms of having to throw the document out, because it's all focused on section 3. which I don't have the language in front of me, but there's a,
Of the comp plan update or the DGEIS?
yes, DGIS.
Oh, okay.
Oh, you weren't involved in it? Okay, so the section 3, one of the, do we have that in front of you? I don't have my phone, so I can, if I have to read it directly, but section 3 listed, one of the 5 items was traffic safety, and I just thought that we should put in there a specific call out of pedestrian safety, not just traffic and pedestrian safety. Right,
okay.
because we've had such a major initiative in the village, and the concern, a lot of the projects the village has been undertaking on Station Road and Main Street has been about pedestrian safety, so that was, the other thing was, although it says it toward the very end of the environmental statement, there's a paragraph at the very end about environmental factors and blah, blah, blah. I thought that in section 3, we really should be calling out something about, environmental concerns, sustainability, climate mitigation, the goals of the village, but also, the community goals to have a livable, address the climate, provide a more livable community. So I don't know how you want to phrase it. I'm sure there's some kind of nice way to package that up in that paragraph, in that section.
Okay.
But I think that was talked about quite a bit by people, some of the concerns. And I guess my third comment was that, weren't we supposed to say something about goats?
For the next plan. If anyone's here, we'll bring it up again.
But otherwise, I thought it was a useful document, and I thought it was good to provide, that does go with the, is it inserted into the comprehensive plan
I-
update?
No, it's not inserted in the comp plan. That's-
Yeah, not in the final, but I think,
It gets circulated with it
right,
to
Well,
the,
good, because I think it should be made
Yeah.
public, because it gives a good,
it is, it's all posted, yeah.
yeah, it gives a good context for a lot of stuff that sort of, when you're reading the comp plan, you don't necessarily, it's kind of a distilled context in the statement.
Yeah.
So,
Dave Smith.
So we can say we accept as adjusted by Mark's comments that seem
Yeah, I'll do some
reasonable?
minor
Okay.
tweaks, I'll send them around to you just to make sure.
yeah, I just don't, I don't think anything like is so greatly substantive that it can prevent us from accepting it, but.
yeah.
Anything else? Whereas the Comprehensive Plan Committee adopted the draft 2018 Comprehensive Plan Update and referred to the Board of Trustees for adoption, and whereas the Board of Trustees intends to hold a public hearing on the draft 2018 Comprehensive Plan Update, and whereas the Board of Trustees has reviewed the draft generic environmental impact statement as amended related to the 2018 Comprehensive Plan Update, now therefore be it resolved to accept the DGEIS as complete, and further resolved to set a public meeting to be held on March 21st, 2018 at 7 p.m. in Village Hall to review the DGEIS and the 2018 Comprehensive Plan Update. All draft comprehensive plan, and to refer the draft comprehensive plan to the Westchester County Planning Board for its review and recommendations. I'll make a motion. Can I have a second?
Second.
All in favor?
Aye.
Renew an intermunicipal agreement with the Westchester County for enhanced 911 services.
Yeah, again, this is, as it says, it's a renewal of an existing agreement, but it basically covers all the various terms and conditions related to being connected to the 911 system. The agreement's been reviewed by Mary Ann, who raised a few issues, questions, concerns, not concerns, but just observations, requirements, and the chief is satisfied. There's really nothing changed here.
5-year term, 2022, that's fair.
But it does put the onus of us having to prove that something doesn't function.
Right.
Is that the same as last contract?
Yeah, there's no change to that.
Yeah.
Resolved to approve the renewal intermunicipal agreement with the County of Westchester to provide enhanced 911 service and to authorize the village administrator to execute the agreement. I'll make a motion. Can I have a second? All in favor?
Aye.
Budget workshop?
So we had a little change of plans, as I alerted you
Yeah.
to, regarding the departments that we're dealing with tonight. So Brenda has some materials that will be handed out.
Thank you. You guys listen to me, I'd listen to you.
That's it.
We didn't have any good visual aids.
Thank you.
Thanks very much.
Come back
I give
anytime.
up too. That's funny.
I just wanted to add to your package here, budget books here.
We're getting
There's
these back
also-
to you, right?
Tonight, yes, I'll take it back. Revenue insert.
Under other.
What is that sitting here?
This goes into other.
You know, the front if you like, or under general revenue, is it general revenue tab, the first?
General government, yeah.
Yeah.
Oh, I got it.
Put it under other, for theater.
I want to give this to you, this is the good service.
Mhm.
Good service, budget.
Oh, right, yeah,
In certain cases.
Mhm. yeah. Yeah, yeah, that's fine.
Okay. Oh, right. As Larry said, we're going to have a little change in plans on the departmental reviews and for opportunity to go over really on a little larger level where we are today with the budget. We did have an opportunity to look at revenues, and after reviewing the current status of where we see going for the rest of the year and projections for next year, we made some changes to revenue that really help our, the bottom line, the tax levy.
So can you just walk us through the changes?
You want, Larry,
No, I don't have, you go
you have
ahead.
one?
You go ahead.
Oh, here.
I have a summary.
Another copy. I mean, exactly the number here. I highlighted in yellow those items that we changed, and the first one was, this is actually the sales tax. So sales tax has been coming in stronger, and if it continues at the rate it has been, we feel comfortable in raising that by $40,000. So increasing that to $970,000 for next year.
I've always been interested, so just maybe give me a summary. How is it allocated by, it's county sales
Per
tax?
capita.
It's just numbers.
Right, it's not the amount that Irvington specifically generates
No,
in
right, I
sales tax.
understand that
Right.
it's equalized out, but
But it's based on the census
This takes out
numbers.
total
Right,
tax collected,
in the
you know,
county.
times our number of people divided by all the people in Westchester. So if we have like, a cash cow here, that makes a lot of money.
it doesn't matter.
It's just the number of people,
I
which is
understand.
why the census bumped us out a little bit when we went down. So, it wasn't a lot, but make sure we count everybody.
Have more babies.
So we were originally saying that we were going to stay flat with what the 217 number was, and the 218 requested,
Yes,
and now we're saying,
We're up.
and this is, this number, there's a few numbers here that are like this, but this is one of them that's economically sensitive. So we try not to push the envelope too much on this, because when you do have a
next year it may
downturn.
go down.
Exactly. So it doesn't fluctuate that drastically. The mortgage tax actually fluctuates a lot more drastically. But I think we're comfortable with the prior year and with where we are in the current year and the level that we're at, so.
So last year, as you see, the amount we received was $966,000. So it's really bringing it up to last year's actual, a realistic number to last year.
And we're on pace for
Oh, we're on pace.
just short of $1 million.
Yeah, cool.
Oh, over here.
The next line in utility tax, we decreased that actually by $15,000 to also bring it into more realistic numbers that we're receiving.
Can you explain that?
Yes.
Sorry, each one, it'd be good to understand this, because it looks like we're at 102,000, I mean, yeah, 102,500, whatever, this year,
That's right,
last year.
Last year, yeah.
last year. So we reduced it from 115 to 100,000. It's based on the gross sales, there's that our biggest contributor is Con Edison. So it would be for utilities.
Natural gas. Not for
Con Ed.
for natural gas.
Natural gas.
Right, so the price of natural gas has declined
Right.
in the last several years, so the
That's why that
associated
number's
revenue.
been declining for
Correct.
15, 16.
So is it just natural gas?
Gas station.
Yeah, it's just natural gas.
That's not, so it's not like Verizon or Fios or, or cable, any of those kind of franchise fees?
No, that's a different line item.
Yep.
That's different, that's.
That's
the next
franchise
one.
fees.
Franchise.
Next one down, plus
Next
30
one
grand.
down.
Right. Next one down, we're increasing that by $30,000, right? And that is really also a formula based on their revenues.
And you can see we've been pretty consistent the last several years.
Right, I was gonna say.
Probably could have increased it last year, but
Right, that was gonna be.
we're catching up, yeah.
So don't give up your Fios.
The other ones we see pretty much as stagnant and not much fluctuation.
Planning board up $2,000 now.
Yeah, big time.
Give them a picnic this year.
So, where's the building department fees? Is that's not in here anywhere?
Yeah.
Building
It's about the fourth line down on the
Next
second
page.
page.
Ah, you mean if I look ahead and see?
I like when you don't cheat, and go ahead, you stay with us.
Yeah.
We've added a line this year for refuse and garbage services. We're billing now for the bulk pickup and for $25 per pickup. So it's not that it's generating a lot of money, but we do want to reflect that in the budget. And so far, since it's been implemented, we've collected $125.
Wow. Time to take us out to dinner.
So anyway,
So building department revenue will respectfully skip over because we would hope to have that discussion in more depth with our building inspector here, hopefully at the next work session. He has a lot of insight on trends and all that, and I'm sure you'll get your questions answered. But as you can see, though, we are not proposing any increase in that line, and I'm sure that he'll be able to explain exactly why.
In fact, we're significantly under where we performed last year.
Right.
So
Right.
that's-
But again, there's a lot of moving parts. From the Ardsley Country Club, for example, $120,000 was associated only with that. I mean, it was, so there's some moving parts here that will be described.
We don't think we're gonna have any filming?
No, what we decided, what we decided is, and we're recommending that we completely take out that line item because that line item is hit or miss in any given year. We've had zero so far this year. So it seems silly to have a budget shortfall just because they happen to have not filmed something in town, whereas the previous year it was, $120,000 or whatever. So it's easier just to keep that at zero, and then anything we get is just a bonus.
Okay.
I mean, it's, there's no way to predict it, frankly.
Here goes Hollywood on Hudson.
Yeah.
So fines and forfeitures?
Yeah, that line item, it reflects the operations of our, the collections of our court, and that's directly attributed to the hiring of the traffic enforcement officer.
Yep, tickets.
Yeah. This is based on the projections that we see. The one thing that you should be aware of is that on the other side, on the expense side, and we weren't going to go through all that in detail tonight, but there is an additional $24,000 for compensation for our village prosecutor. He's putting in an exceptional amount of more hours than he was before, and that's because of the caseload. So this is not all gravy that you see here. there is a,
Mainly gravy.
well, yeah, no, it's not
Gravy
zero,
with a
but
couple
it-
of chunks, okay. that's
right,
fine.
so it's 60,000 minus 24 essentially is the relationship here.
Still, it's,
It's not zero, but it's,
not that we, anyone likes seeing traffic tickets being a source of growing revenue, but I guess if the result is slower traffic on, and more stop sign compliance, yeah, thank you for the word, I was going to say compliance, but compliance.
Well, once we change behavior, we'll have a lower number of foot miles.
I'll tell you when
That doesn't seem to be changing.
yeah, no, they're still
In the
going,
next-
but
When the millennials
We'll
are,
happily take the
we
miles.
look at this, every quarter and review it with the traffic committee, so we'll, if we see a trend declining, we'll see it right away.
Okay. Did you want to go on to the mortgage tax?
yes.
With that one here. That we're recommending to increase to 200,000. I have an accrual to reverse, I believe I didn't, that's why it's not really 300,000 year to date. If you look at last year's, we brought in 206,173.
Yeah.
So we're bringing that closer in line with what we anticipated. And then,
That's one of those, it's, again, it's actually much more economically sensitive than the sales tax. It fluctuates more widely, so 200,000 is conservative. If we exceed it this year, that doesn't mean we're going to exceed it next year, so we're just
Is
trying
it
to,
based on actual sales? I mean,
it's actual mortgages that are taken out. Originated on properties in our village, yes.
that's what I mean.
Yes, this one's not an allocation, this one's, I believe, right? Yeah, because it's.
So
put
something
on-
like the Donardo project, Marker Ridge, that's going to be 20, how many units? I keep forgetting the numbers. 20, 27, 28, 20, yeah.
Less than 36.
Yeah, but I mean, all except for the affordables are they, I don't even know, the affordables going to be, the
for
rest of
sale.
them are for sale, right?
They're all-
Everything's for
they're all
sale.
for sale, yeah.
Yeah, so that should be a spike, right?
Sure.
buy your
When
place
is that
and all
what-
that.
You don't need a mortgage.
Okay.
Well, I mean, and permit revenue as well. I mean, but do you, one-time spike, do you increase your budget based upon a one-time spike? It's
Yep.
hard to do. You know what I mean? What we've done in the past is we've tried to be steady and
You have
sure.
a moving average is what you're saying.
Right, and if
I've
there
been
are,
hammering Larry about this for about 2 years now.
About spikes or moving averages?
About moving it, just because, and then
Yeah.
I think Larry's right though, it's like, it seems like for the last 3-4 years, we've had kind of a reason for the spike each year, but each one is temporary, it's like, it's a true spike, as opposed, even though it's multiple spikes, they're true.
but if you keep it at a reasonable level and you exceed it 1 year or more than that, you're putting money in the bank. You can use it on one-time capital things that we've done before. You can keep it in the bank so that when those years don't spike and you're below what you expected, you have some cushion, so.
It's fine, it's funding.
But, I mean, it seems like
Get a little bit of
the
that.
revenue side of the ledger.
That's what it, now can you talk about the last one, the federal emergency aid, that's just.
We have to pay money
No,
back.
sorry,
No, that's actually not.
surplus.
Yeah, it's not, it's surplus, right.
Well, yeah, right, what's surplus?
So our recommendation, this is the appropriation of surplus that,
Oh, they're right, okay, got it.
Fund balance.
right, so
Right,
using
that's
fund
using-
balance, so,
Thank you.
our fund balance levels are healthy. They're
Over 25%.
over 25%, which is above,
We want to be about 15,
well,
10 to 15.
yeah, 15 is where we want to
A
be.
lot of money in.
20 is acceptable.
25 is where the rating agencies want us to be, so 25 is getting to be the upper limit. We need to use a little bit
We've
more,
had
that's a
How many
good
good years in
thing.
a row?
Many.
As many as I can remember.
Yeah, so
So
that's a
this is
good thing.
another one that's tuned
Yeah,
every year.
yeah, well, this is a line item that
We control.
is, you control it completely, as you do most of these, but you can play,
Right, I mean, this
Many
is gonna
communities
offset
do.
quite a bit of change in departmental budgets.
right, And you could pump it up considerably higher if you wanted to, but you're only gonna,
Levy down,
but you're only gonna,
year.
yeah, you're gonna have a problem in the future. so.
That's exactly right, exactly right.
But we feel pretty confident that this level of use of fund balance is sustainable. You're not gonna need to have some big budget hole next year to take this number down, because all of a sudden you have no more fund balance. I think we're at a level where you can use a little bit more.
Okay.
Okay, so if you open your books, the first page you see is the calendar schedule. The next page has given us a one-page overview of the expenses and the revenues that
We should
comprise
just
this
go by the
budget.
way. What
Now,
section?
open up the
General.
book. Just before general,
No, he's asked where to put his
oh,
revenue
I
sheet.
guess
We asked that earlier. We had sidebar conversation on it.
Okay, got it done. All right, sorry, yes, we're at the
So just
summary.
go and, get the very first page is the schedule. The next page is a new insert here, and it outlines the change in revenues and the use of surplus and how it's impacted this particular budget. So you can see that the revenues, we increased our revenues by 136,000, but it actually decreases the levy. That's why it's a negative
Oh, okay.
number. Right. And it, the impact would be a 0.97 decrease in the levy percent. So if you go down, then the use of additional surplus also decreases the levy. And then our expenses at this time are $767,000, an increase of $767,000. Which is an
Those
increase.
expenses are the budget presentations which have been made up till this point in time.
No,
Right.
that's
plus-
just departments, right?
Well, yeah,
We haven't really finalized all this, but
No, but I mean, it doesn't include rec
Recreation.
and building department.
Correct. It assumes essentially a flat,
I believe a building basically is flat.
it's basically flat,
Is
yeah.
flat.
And same with recreation. For now.
For now, it does not reflect any new changes in recreation right now.
Right. But all the other changes that you've heard about from the other departments, as they're rolled into that one line. We
But
didn't
we
go
made a
through.
few
and-
other ones along, since the certiaries we increased, which we didn't get to.
No, I'm saying, but the one line item that's here, departments, 183,000, those reflect departmental increases that you've heard about from the other departments. Right. So the other line items that are detailed there are the major expenses, which we wanted to at least have a brief discussion on tonight, so that you're aware of them and understand what's in this. These are major components in your budget that need some explanation. So salary and benefits, we've talked about before. We won't talk about it in detail here, but you have a union, CSEA union contract that's been settled, so those numbers are reflected and included in that number. You have a police union contract that hasn't been settled, but there's a provision set aside to cover anticipated settlement on that. And then also a provision for non-union employees. All of those are rolled into that one number with a little bit of out-of-pocket benefits like Social Security. Health insurance, I don't know how much detail you want to go into, but we essentially have our rates projected. Well, we have our rates currently in this 2018, but the 2019 rates are also projected, and
We have 9% projected, we've been
Yeah.
having 9% increases year over year.
Great.
And even though we have newer employees contributing to the health insurance, it still exponentially just increases by this level. Our medical health insurance is over $2 million a year right now. So that's how we come up with a $200,000
Well, a lot of people with
projected increase.
private medicals, and the exchanges are seeing two-digit, like 20%, right? Between one year and the next.
Right.
Between last year and this new year. So
Right. And this is Empire plan that we're all members of here is a very large and pretty stable group. You know what I mean? It's not something that has people coming and going a heck of a lot. It's a very stable group. So, you know, it's hard to beat the premiums in this particular plan. I'm not saying it's impossible, but it's a very stable plan. And even then, they're projecting, you know, 9% increases. It's the industry. Debt service is straight from the decisions that you made back last May about the capital budget. So there's a time lag in those decisions that you make about which projects you want to undertake in a particular year, and then the debt gets borrowed this past year, or the current year that we're in, and you start making payments on it in next year's budget. So none of this is unanticipated at all. Certiaries, we consult with our counsel, Ed Lammers, Marion's partner, and he provided us with a projection of what he sees settling in the next 6 to 12 months. So coming up in this upcoming fiscal year. We've been fortunate to take down our certiorari number over the last couple of years. It used to be up over 300,000. We had taken it down into the high 100s, I think it was.
Exactly.
Based upon what he sees, we probably need higher than what we have, and that's what this is, to increase this by 50,000. I'm not sure what the final number ended up being, if you have that.
How does the
I didn't take
reassessment?
that down with me.
No, well, yeah, so how does the reassessment impact? So, as best I can tell, the settlements that are taking place right now are largely pre-revaluation. So they include years that are prior to the revaluation. So it's hard for me to say exactly how it's going to impact it. I would think common sense is that we should see less over time, but these are old cases that are being settled, so we're not quite getting the benefit of that just yet.
I guess the question is, are there new cases coming in?
Yeah, we had filings last year, just like normal.
It filings there are a lot of grievances that were settled and scars that were settled. As that's now certs, but they ultimately come out because they're in the current year.
Right.
That was about 100,000 for this year alone in scars that was settled.
Right. But the large commercial cases,
large
we still
commercial-
get filings, but
Aussie Country Club was another one, the fire damage.
yeah, that's a one-time thing. though.
That's a one, we have the budget for it.
No, I understand.
You mean they were getting a reduction for the 1 year repair?
Yeah.
Operational impact, or whatever.
Yeah, I mean, it's all based on rent and commercial
Yeah.
viability in terms of the value. So, anyway, that's what we see. If we haven't, Brenda, I'm sorry, if we haven't shared the memo with that one.
Sir, I'd be happy to.
Yeah, we'll share that with the board in your Friday folder.
Okay.
It's helpful just to see the activity.
Yep.
Anyway, but I don't think there's a crisis going on here. I think that we've enjoyed a few years of relatively low numbers, and this is looking like it's a little higher. We've been pretty good, to Ed's credit too, we've been pretty good with settling these things out in an orderly fashion. So we don't have, $500,000 1 year and then nothing the next year. It's been a pretty orderly process. So this is
None of them are
part of that.
surprises, they've been on the calendar for some time.
right. Well, I broke out police overtime in this list. It's part of the departmental discussion that we had, but that was a separately identified one. I thought it was appropriate to list.
That was already discussed, right?
It was, yeah.
I was looking at it going,
No,
is
it's
this in
not.
addition to what?
No, I just thought it made sense to break it out and not bury it with the rest of the departments. And that's it. Then we do have I think Brenda has reported earlier that we do have an increase in our assessment roll. It's largely due to the
The phase-in
the phase-in
exemption.
exemptions being lowered, one-third, one-third, one-third.
How many years, are we 2 years into it now? Or
This is the second year. Next year, the phase-in exemptions will be zero. So we'll have another benefit like that. Well, I don't know if it'll be the exact number, but we'll have another bump in the assessment roll because that'll be the final year. They'll go to zero. Right?
That's correct.
Yeah.
And then everyone's gonna be living in tents anyways, so. Sorry.
Other
So
decision.
basically, right, by having that extra assessment on the roll, it minimizes your levy increase. The levy goes up.
Oh, I understand that,
But-
yeah.
right. The taxes go up for the overall village, but the impact is reduced across the board.
Yep.
So this is, as presented currently, this is tax cap compliant. I think we've told you that before.
Go to the next page.
It's hard to tell just by looking at this because the 2.5% for the roll increase actually has no part in that tax cap calculation. So the actual increase, is actually closer to 4%. But because of the way the cap is calculated, we have a cap that's much larger than just 2% this year. But anyway, that's the net, which is what is most important to people, is below 1.5% at this point.
At this point.
Can you, what are we picking that for?
Go to the next page.
I was adding 1.5 and 2.5
Right.
together.
Oh. Gotcha.
Yeah.
So the net result is an increase in the tax levy of $556,000. And that's then illustrated, you see on the next page, we have the tax rate summary. The last column, right, is where we are currently. We can add out the increases in revenue against the increases in expenditures. The net difference is $556,000. If that were the levy today, it would be a 1.43% increase in the tax rate.
And from prior presentations that this tax rate summary is a little bit more populated than normal. There's actually 3 separate columns for 2018-19. The first, the third from the right is if there was no increase in the tax levy at all, what the tax rate would be.
So that's illustrating the impact of the assessments alone. If you had the same budget, but that new increase in assessments, it would have resulted in a decrease in the levy.
Right.
Tax rate rather, tax rate.
The second from the right is if you exhausted all of your tax cap available,
Yeah.
what your tax rate increase would be.
Bad.
And then the last column is what we're talking about here. So that's what the current budget is, as projected. So this gives you a little more context in terms of how all these pieces fit together. You sat here and listened to the departments.
Right, and we kept saying, but you're asking for 5% and you're, right, now we see where it fits in when you see the.
Right, because you have-
Especially the adjustments.
Exactly, yeah. And you have revenues that have increased, but you also have, some pretty large benefit numbers that have increased as well, so.
Very good. Thanks for that, guys, as always. Trustee liaison reports.
Is that where we are?
We
Okay.
are.
Tree Commission's meeting tomorrow night in Normal, at the library in the local history room, 7:15. I guess I should say it for each of the various committees, but the Tree Commission is looking for additional folks who want to be involved in the Commission's activities of public education about trees and also managing the permitting process and review of that. The Traffic Committee has not had a meeting recently, and I'm not sure when the next one is, but they also are looking for community involvement, neighborhood folks. And finally, the Green Policy Task Force is trying to get themselves functioning fully again with some regular meetings. The discussions are still ongoing, so I'm not sure when that's going to really come down to whether it's going to be a monthly, a quarterly. There may be they're talking about more regular meetings of individual work, project task forces, so we say, and then a more irregular meeting of the main committee. So if you're interested in either of those three, certainly contact myself or Larry, and we can then forward your information off to the committee chair to look at and get in contact with you and talk more in detail about it. Excellent. That's it.
I would just like to make an announcement that there will be an annual Fair and Affordable Housing Expo on March 10th at Westchester County Center in White Plains from 11 till 4. The expo provides an opportunity for people to meet with nonprofit housing counselors, real estate brokers, mortgage lenders, and other housing professionals to talk about their individual circumstances and desires and to attend workshops. I'll echo a couple of things that Brian had said earlier. The weekend storm took a big hit out of our parks. Matheson had a tremendous amount of debris washed into the park, and we lost a few tables of riprap. Scenic Hudson did better, but the edge of the park lost a great deal of topsoil, and railroad ties were moved in addition to having debris washed into the park. Olsey Pond has some damage, as do the trails. Cleanup will be labor intensive.
Isn't that covered by, we weren't declared a disaster area, right?
Yeah, it remains to be seen. I'm sure the county is accumulating numbers. They haven't asked us yet, but I'm sure they're going to be accumulating numbers about damage to public property, which will then roll up into the state numbers, and I believe the state numbers have to exceed a certain number before a disaster is declared.
How are we going to deal with the boat club dock catastrophe, disaster, whatever, it's really taken quite a hit and is now left the fireboat inaccessible, so that's
Maybe our opportunity to make a marina.
is that something that is, because it's public access to the fireboat, is that, I know it's a private pier, but.
I think first of all, I think it's too early to say, but there's also a third party involved, which is the owner of the barge. So, and I believe there's been contact between them and the boat club, so there's a couple of parties here. So I think you can make a case for public involvement, but I don't even know if there's going to be a FEMA disaster declaration or not.
Right.
I mean, we don't know.
I was
But
just
I think-
thinking in terms of throwing money into the pot, in
Yeah.
terms of increasing the negative impact value.
Yeah, again, we'll have, it remains to be seen, how each of those things plays out. But my gut sense is that the contractor is responsible, but that remains to be seen.
Was there other damage at the waterfront? The bulkhead, along the Bridge Street property, or anything else that we know of?
Not damage to the bulkhead, no.
I mean, there was a lot of sediment and debris
Yeah.
on the other side of the
That's
bulkhead.
Larry.
Oh, yeah, well, but that was all from wash over,
Right.
over the top of the bulkhead. It was,
Turned over the picnic tables and stuff like that.
yeah. I mean,
But there was no bulkhead damage that we know of.
not that I know of, no. I haven't heard anything from Bridge Street. We were down there, and it was actually quite awesome we were sitting in a car, of course, on land, looking at the river that was probably 1 or 2 feet higher than the land we were sitting on, and it was, at the top of the bulkhead and just washing over. It was pretty awesome, yeah. But that was after high tide, so we knew it was going down. So,
Did you see the barge?
which one?
The
one that was docked?
That's a picture of it.
Yeah, no,
I did see a picture on,
Yeah, we saw the picture with the one with the girder is particularly harrowing.
I was wondering what was in the two storage containers that were on the, or shipping containers that were on the one barge that was down by the.
Oh, on our beach? Yeah, I don't know.
Construction material.
So,
Well, I'll just mention there, the next meeting of the Recreational Parks Advisory Committee is Wednesday, March 21st. The Woods Committee on Thursday, March 15th. The Community Advisory Board on March 13th. I ask Executive Board, the committee on March 20th. The Summer Day Camp is going to be holding an open house on March 10th. And there are staff job applications available now at the rec office for those who are interested in a summer job at the rec. And last of all, just again to mention the FACE 2018 Spring Fest event. It's scheduled for Saturday, May 18th. Plans are in full swing. It'll be a great family event, including food, entertainment, kids' play areas, and much more. We are looking for sponsors for the event. If you're interested, please contact either Joe Archino, Mike Donardo, Bob Brados, or Mayor Smith. That's it.
Thank you. Connie?
Oh, okay, so, yeah, more on the storm. The Highway Department described this as storm number 12. I guess we're gonna get 13 in a day,
Seems that
or
way.
2 days. But this was this nor'easter, rain, sleet, hail, ice, snow, wind, trees down, public and private, many blocking roads, as we all know. So they have also been in, that was a big part of their activity, obviously, but in addition to that, maintenance of their winter equipment, and then cleaning up after this storm. And then there was also a catch basin at the corner of South Buckout and South Astor with a precast concrete catch basin that was replaced. And then the potholes, of course. And the water department, as always, reading water meters and doing their winter maintenance. Space Age Alarms is updating all water department facilities. WCDOH, I'm not sure what that stands for.
Department of Health.
That's just-
Okay, yes, performed their annual sanitary survey, passed no violations, monitored all buildings and facilities during the storms and afterwards. And my other report is, just to say that I've now counted 3 meetings with the Chamber of Commerce and another one tomorrow, so essentially looking at their role and the possible activities and involvement for the Celebrate Irvington event. So stay tuned, I'll tell you more.
The only thing I have is a report on court actions and fees, which sadly is sitting on my desk at home, so I will report on that next time, and nothing else to report.
Village Administrator's report.
So, the 2 things to report on. There was a meeting that I took part in this past Tuesday, I believe it was, with a prospective insurance carrier. It was a meeting that Brenda actually arranged, and we coordinated meetings with the departments. We are looking at a possible replacement for our insurance program. That's our regular insurance program, not our health insurance.
Health insurance.
So it's our regular insurance and our workers' comp. And so we've done a kind of a mini RFP where we have an identified carrier that is not ours, and then we have our current carrier, and we've asked them to submit proposals based upon potentially a different model of insuring ourselves, not complete 100% indemnity, but some mix of a self-insured and indemnity type scheme. So we'll see what comes back. There could be potential for savings. If there isn't, then we won't change. We'll see how it goes. The other is a meeting that's coming up next week, which I believe I reported to the board, relating to the potential resurrection of the Community Development Block Grant, Urban County Consortium that Westchester County had been historically involved in, and had in recent years decided to give up participating in. And frankly, it was the only means of funding under CDBG is if we're part of an urban county consortium like this. Competing for statewide funds for CDBG for Irvington is virtually impossible, and we've not done it in the last couple of years. It's fruitless. So we'll see how that meeting goes. It's over at the county. I think I reported it, and I think someone said they were going to go, yeah.
Better kind of situation, or is it just sufficient to have representation and you'll report back?
I think,
Two of you is fine.
yeah, two absolutely fine, yeah. Yeah, no, it's not a,
If I
we're not
can
marching,
signal, let you know.
we're not marching on the county. The county did this,
Right.
set up this meeting, so they're exploring the idea of reestablishing the consortium.
Village Clerk Treasurer's report,
Nothing further tonight.
Village Attorney's report.
On report on indemnification. No, I was kidding.
I know.
Public comments? Review of action items?
Other than setting up a work session with the Irvington Land Trust, which I knew about already, and, I'll be working with the gentleman that was here tonight to see what his concerns are.
I'll make a motion to adjourn if I get a second.
Second.
All in favor?
Aye.
Opposed?